Thank you. And just very, very briefly before we start the next panel, we are met at one of the nation's great law schools, and it is altogether fitting and proper that we should do so. But the two organizations that are sponsoring this event exist in part to take very important conversations that are going on in the academy and making sure that those same conversations are being heard and joined in by the bench and the bar and the media. And therefore, we're especially pleased that we have some very distinguished attendees joining us today. Judge McConnell, obviously, who was on the last panel. Also, Judge David Tatel and Judge Lynn Edelman. And I think some other very distinguished judges will be joining us later in the weekend. Also, Linda Greenhouse, late of the New York Times, now of Yale Law School. And also John Cowell of the Ford Foundation and Tom Hilbink of the Open Society Institute, both of whom have been great friends and advisors to both sponsoring organizations over the years, and without whose wise counsel and unstinting support we wouldn't be here today. So thank you to you all. I know the organizers of the conference were very focused on the idea of having a conversation that went beyond the panels, and I think the questions from the floor after the last panel were a testament to the wisdom of that judgment. Thank you all for your participation, and thank you all also for your patience with the microphones, which are helpful both in helping people here in the room, but also make sure that your questions and comments are a part of the video record that we're assembling of this event. So thank you.
Thank you. My name is Anil Calhoun. I teach at the Drexel University Earl Mack School of Law right across the street. I'm pinch hitting for Garrett Epps, who unfortunately was not able to join us as moderator today, and we of course all send him our best. We have another great panel here. I'll introduce folks in the order in which they will speak. I won't give detailed biographies since you have them. We'll begin with Roger Smith, who's the Christopher H. Brown Distinguished Professor of Political Science here at the University of Pennsylvania. Then we have Christina Rodriguez, who's an Associate Professor of Law at New York University School of Law. Then we have Margaret Stock, who's an Associate Professor in the Department of Social Sciences at the United States Military Academy at West Point. And then finally, Lucas Gutentag, who's the National Director of the ACLU Immigrants' Rights Project and my former boss. So, Rogers.
Thank you, and I regret that too many local obligations have prevented me from participating in this terrific conference with lots of people I admire and respect more than I've been able to do or will be able to. The 14th Amendment begins, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. This is the first definition of citizenship in the United States Constitution, and there is agreement on its original purposes. Its primary purpose was inclusive. It overrode the Dred Scott decision and conferred citizenship on persons born in the United States of African descent against the Dred Scott ruling that no such persons could be citizens of the United States. But it also had a secondary exclusionary purpose. The phrase, "and subject to the jurisdiction thereof," was presented as a means to make sure that those Native Americans still living in tribal relations within tribes would not be extended birthright citizenship. Only those of Native American descent who were assimilated into the broader American society. The clause, however, does not really succeed coherently in accomplishing its purposes because the phrase "and subject to the jurisdiction thereof" does not really logically exclude members of the native tribes, since the United States did claim ultimate jurisdiction over the tribes. So they were subject to the jurisdiction thereof. And that, I think, is an inherent problem with trying to make the language accord with the undeniable original intent. The clause does present another problem, or at least so Peter Schuck and I argued in 1985. The clause is usually read as incorporating the common law rule of jus soli, citizenship by place of birth, although it does not use that phrase. And that doctrine, historically, was stemmed from the feudal notion that you own perpetual allegiance to whoever was sovereign over the land on which you were born. But the American Revolution began in rejection of the notion of perpetual allegiance and sought to create a political community that we understood to be based on consent, with membership itself a product of mutual consent. And so we were concerned to see how the institution of birthright citizenship could be reconciled with consent, as well as to try to make as coherent as possible the language of the clause. And we argued that, in fact, there were international law writers, Émeric de Vattel, Jean-Jacques Bernard-Maquis, who had already wrestled with this problem and understood birthright citizenship in more consensual terms, focusing not on place of birth, but rather on the notion that the social contract which should be understood to underlie Republican society is one in which all those who have been granted membership are entitled to confer that membership on their children as a condition of their own consent to membership. And we noted that Vattel, in particular, his doctrines were used in American law to define the status of the native tribes, and that the subject to the jurisdiction phrase motivated to exclude the native tribes who had never accepted American sovereignty, even though the United States claimed sovereignty over them, that subject to the jurisdiction clause made sense only if we interpreted birthright citizenship in the 14th Amendment in more consensual terms, as extended to all those to whom the U.S. had granted permanent residence and the children of all those to whom the U.S. had granted permanent residence, but not to those whose presence in the U.S. on a permanent basis had never been approved by the U.S. government. And that meant that logically our position implied a denial of birthright citizenship to children of illegal or undocumented aliens, a category that barely existed at the time of the 14th Amendment. But we suggested that now that it does exist, the 14th Amendment ought to be read not to confer constitutional citizenship on such children, but rather it was a choice of Congress to make this decision about their birthright citizenship. That argument has been widely criticized, and I want to suggest today that one powerful criticism has gained force since we wrote in 1985. One of the criticisms against us has been that since Americans have acquiesced over time in interpreting the 14th Amendment to grant birthright citizenship to all on U.S. soil, including children of undocumented aliens, the consent objection is answered by the long-time acquiescence in this policy. Now, we didn't find that very convincing in 1985 because there weren't undocumented aliens really at the time of the 14th Amendment. No Supreme Court decision had ever addressed the status of undocumented aliens, and frankly, until we raised the question, nobody was even asking this question of whether it applied to children of undocumented aliens. To say that we had actively consented to extend such citizenship did not seem plausible to us. Now, it seems plausible to me. It seems plausible because, beginning in 1993, in every session of Congress, legislation has been introduced that calls either for interpreting the Constitution to deny birthright citizenship to children of illegal aliens except for long-term residents, or for Congress to take that position as a matter of legislation. The 1996 Republican platform endorsed this position on behalf of an unsuccessful candidate, and those efforts continue to this day. In the 110th Congress, 57th congressmen have co-sponsored a Birthright Citizenship Act of 2007, which would interpret the 14th Amendment legislatively to provide citizenship not to provide citizenship to children of parents who are not legally in the United States. So there have been repeated efforts in democratic debate to raise this issue of how the 14th Amendment should be interpreted, and they have been overwhelmingly rejected. None of these efforts have gone anywhere, and therefore I submit it is more plausible now than it was in 1985 to say through democratic processes American people and their representatives have considered the question of the applicability of birthright citizenship to children of undocumented aliens, and they have rejected any effort to alter the status quo. They have accepted the extension of such citizenship. So the objection based on consent theory that we raised is, I think, not persuasive now in a way that it seemed to us then, or rather consent has been given, which I take as a tribute to democratic processes. And I want to note that because recently a new challenge to birthright citizenship has arisen. The legal scholar Ayelet Shakar, in her new book, The Birthright Lottery, argues against birthright citizenship not from the standpoint of consent theory, but from the standpoint of distributive justice. In brief, globally, birthright citizenship means that people, through the accident of location, some are born into societies with extraordinary resources and advantages compared to others. And she regards this as profoundly unjust, and so calls for modifications in the institution of birthright citizenship or some efforts to provide compensation to those who are less advantaged. Where this will go, I have no idea, but I do want to indicate from experience that putting controversial and in some ways what may seem like very unconventional ideas into public debate can be a worrying thing, but it's not clear that we actually always need to fear the processes of democratic deliberation, so contributing ideas that might enrich them is a worthwhile thing to do.
So I'm not going to address this consent theory directly, but I do want to just make one observation, and that's that I think among the reasons why these repeated attempts at amendment have failed is because of the deeply rooted assumption that they would be unconstitutional. And so I think that requires that we still engage the question of whether, in fact, it would be unconstitutional to do that. And the approach that I want to take is to talk about the meaning of the Citizenship Clause in relation to the rest of the 14th Amendment. And I think that understanding the scope of the Citizenship Clause in terms of original meaning, and I'm also going to focus on that particular question, though I think that Roger's approach to taking acquiescence as a sign of understanding of the meaning of the Constitution for a contemporary generation is a salutary one that I would follow. But I think that addressing the meaning of the Citizenship Clause from the perspective of original meaning requires that we confront three difficult interpretive challenges that arise in constitutional law and originalist interpretation generally. The first is, how do we understand the meaning of a constitutional provision that we know had a very specific purpose, in this case overruling Dred Scott, but did so with general language, in this case with a general, nearly universal use solely principle in the amendment that applies without respect to race. And constructions of the 14th Amendment that included prohibitions based on race were ultimately excluded in favor of a general rule. The second question is, what weight do we assign to the first attempts to interpret the constitutional provision after its passage? And in this case, the example would be the case of Wong Kim Ark, decided in 1898, 30 years after the amendment, that addressed the question of whether the children born to Chinese immigrants who are not themselves eligible for naturalization were birthright citizenships under the clause. And then the third, and this I think goes to the heart of the work that Rogers has done with Peter Schuck, is how do we treat the original meaning of a constitutional provision when the source of constitutional debate presents a set of facts that the framers, the ratifiers, or whomever else was present at the time could not have foreseen. In this instance, the effect of the Citizenship Clause on the children of unauthorized immigrants, which did not really exist as a legal category of any significance in 1868. So I think that the basic approach that it makes sense to take, especially because we're here to talk about the original meaning of the 14th Amendment, is to lay out what we know was understood at the time to be contemplated by the clause, but that the inquiry should also extend to placing the clause in the context of the 14th Amendment more broadly. And that if we understand the 14th Amendment to embody as a whole an anti-caste or anti-subordination principle, then we ought to also read the Citizenship Clause in that spirit. And that the bottom line is, and this is how I would regard the Citizenship Clause, is that it's essentially the constitutional reset button that basically, when read in historical and textual context, ensures that all people, regardless of ancestry, are treated on equal terms at birth with a legal status that cannot be denied them by legislative majorities. So the first question is, what do we know about the meaning of this Citizenship Clause from the original understanding? And as we've both established, it was clearly intended to overrule the specific holding of Dred Scott that blacks could not be citizens of the United States, and to establish that the common law rule of birthright citizenship, which was thought to apply to all whites up until the Civil War, now applied without regard to race. Some also at the time saw this rule as necessary to actually secure the meaning of the 13th Amendment, that the prohibition on slavery couldn't actually be secured. And this was in the debate more on the Civil Rights Act of 1866, which included a similar provision, could not be secured without something that guaranteed this basic from-birth citizenship right. And so you can, from that, extrapolate that the 14th Amendment the Citizenship Clause was intended to reject the conception of citizenship embodied in Dred Scott, that it was a function either of the status of the person or perceived capacities of blacks by the majority as a whole. And in that sense was intended to create a prophylactic rule against a majority's ability to deny persons born in the United States of the legal status of citizenship based on prejudice. The other thing that we know about the 14th Amendment is that it was understood to extend beyond the specific case of the newly freed slaves and of African Americans. And there was also, a couple of years after the amendment was passed, a law passed in Congress permitting people of African descent to naturalize. So those who weren't born but were of African origin could naturalize. 3 minutes left. Okay, so it was understood to extend beyond the specific case, but it wasn't clear how far. And the major unresolved question was whether the clause's general language would extend to the U.S.-born children of Chinese immigrants who were ineligible to naturalize. This question was raised and debated in Congress. In President Johnson's veto message of the 1866 Civil Rights Act, which again included a similar provision, he noted that the clause could be interpreted as applying to the Chinese and to gypsies. And it wasn't explicitly answered until the court's decision in Wong Kim Ark. So then the question becomes, how do we understand the construction the court gave it in its first attempt to answer a question left open but clearly pressing at the time that the amendment was adopted, and even more pressing by the late 1890s when Wong Kim Ark was decided and the furor over Chinese exclusion had come full flower. So what does Wong Kim Ark tell us? And I think very basically, Wong Kim Ark, by holding that the children of Chinese immigrants born in the United States were, in fact, citizens of the United States pursuant to the Citizenship Clause, regardless of the fact that their parents were ineligible for naturalization and not considered to be capable of entering the polity, is a powerful rejection of the idea that one's status depends on one's parents' status. It's a basic anti-inheritance rule that clearly has presence in other dimensions of the Constitution. As others have noted, the Constitution rejects inheritance as a basis by rejecting titles of nobility as a basis for status. And it's arguably become a defining feature of American constitutionalism with the focus on the individual and the prohibition against the inheritance of some form of illegality or discrimination on the basis of ancestry. Now, Wong Kim Ark doesn't itself use these precise anti-inheritance terms, but it's clearly concerned with the creation of castes in society and cites other contemporaneous cases like Yikwo versus Hopkins, and in that sense focuses on the impermissibility of construing the Citizenship Clause in a way that would draw distinctions on the basis of race. Now, in that sense, it makes it arguably distinguishable from the case of undocumented immigrants, where the concern would not be the creation of race-based castes, at least not formally, though de facto that certainly would be what would happen. But it does suggest a reading of the Citizenship Clause done in the egalitarian spirit of the 14th Amendment as a whole. And there's a really interesting passage in Wong Kim Ark that I think that we can generalize for a modern context, where Justice Gray says that we couldn't possibly deny the children of Chinese citizenship status because we don't do that to the children of Germans or Scottish people or the English or any of these other nationalities where there was no controversy over whether the children of immigrant parents could become citizens. And again, that was motivated in part because of the racial dimension of it. And that's why there's much discussion of the Yikwo case and the interpretation of the Equal Protection Clause as applying to all persons regardless of their race. But it also reflects, in a sense, an adaptation of the citizenship principle to an immigrant society. That a society that is made up of large numbers of immigrants must have a citizenship principle that is not dependent on an inherited status. It's one, as I said, that has to reset on a perpetual basis. And there's something of that in Wong Kim Ark. And the last thing that I'll say is, and this is the question that these remarks, in a sense, leave open, regardless of whether we take Wong Kim Ark as a decisive interpretation, some people argue that it should just be overruled and we wouldn't have to get around this problem that people functionally equivalent to undocumented immigrants, which were the Chinese in the late 19th century, were treated as being able to have children who could be birthright citizens. But it raises this larger question of what exactly it would mean to give the Citizenship Clause an egalitarian construction. And I think that a universal jus soli construction is the one that has the most egalitarian possibilities. And Garrett Epps, who couldn't unfortunately be here today, would have made a similar argument drawing on principles of anti-slavery ideology and thinking that the amendment as a whole should be understood as an anti-caste amendment, and that a citizenship rule that permitted something like parent status to translate into whether or not someone fell within the terms, the otherwise broad terms of the Citizenship Clause, would essentially give rise to the possibility of the creation of castes. And Margaret's going to talk a bit more about the way in which developed empirical evidence, especially experience from other societies where there's not a universal birthright citizenship rule, suggests that this is in fact the case. But I'll just leave that out there as a proposition, and we can perhaps discuss it, that this would be a more egalitarian rule, though certainly not in the global sense, as Rogers has pointed out, others have pointed out. That leaves also open the question of what exactly that subject to the jurisdiction thereof clause means. And part of the function of reading the Citizenship Clause in relation to the rest of the 14th Amendment is to make an argument for construing that clause quite narrowly in the way it was intended to function, which was to exclude the children of diplomats, the children of invading armies, and the children of Native Americans. Those things are quite clear from the original understanding of the amendment, even if it presents a logical problem in the way it was written. And so given that those things are clear and are difficult to get around, I think we can nonetheless read the part of the clause whose significance is not altogether clear based on the original meaning together with the rest of the 14th Amendment in this egalitarian spirit, which would resolve contemporary controversies on these particular grounds of whether undocumented immigrants' children can become citizens, to suggest that there are no limitations on that rule other than those that we clearly know to have been intended.
Well, I think this is a great time to be discussing birthright citizenship and the meaning of the 14th Amendment, because I believe this is the first presidential election that we've had that I can find documentation where both major party candidates have had their entitlement to the office questioned in lawsuits stating that they are not citizens of the United States, or not at least natural-born citizens of the United States. Senator McCain has faced numerous lawsuits about his status, having been born in the unincorporated territory of Panama, and he has fairly clearly not a 14th Amendment citizen, but a citizen by derivation. Through his parents' citizenship, he gained American citizenship, and then possibly by act of Congress. And then Senator Barack Obama has had his citizenship questioned. There, the theory is a little bit different, though. It was proposed in a lawsuit filed here in Pennsylvania by a Democratic lawyer who opined that because of information he had uncovered, that Senator Obama was actually born in Kenya and was therefore not a natural-born citizen of the United States, and the lawyer had various other theories. Both of these theories have been struck down by federal judges, either liberal ones or conservative ones, depending on who you talk to, on standing grounds without getting to the substance. So although Rogers Smith would have us all think that these matters have been settled, I believe that Professor Siegel's discussion of constitutional culture may be more applicable, because it appears to me that there actually is some kind of uprising going on within the constitutional culture these days in attempts to reinterpret or rethink how the 14th Amendment Citizenship Clause should be interpreted. So it's a great time to be talking about this issue. And my interest in this issue comes not from my involvement in political election campaigns, but in my involvement in the immigration arena, where indeed a lot of these things seem not to be settled. And I believe that Lucas is going to address this issue as well. But they haven't been settled because we're currently having a major problem with immigration in this country, a great deal of dysfunction in our immigration laws. And one solution that people have perceived to the problem of immigration or illegal, unauthorized immigration to the United States is a new interpretation or a different interpretation or a reinterpretation, a revision, if you will, of the 14th Amendment Citizenship Clause. The thinking being that if we reinterpret, revise, we'll have a solution, perhaps, to the problem of undocumented immigration, or perhaps a partial solution to the problem. Before I get into the substance of what I'm going to talk about today, though, I'm required to tell you that everything I say today is my personal opinion only. It's not the opinion of the United States Military Academy, the Department of the Army, the Department of Defense, or any other government agency. Thank you. I like to start discussions about birthright citizenship and what the 14th Amendment means with a story. So I'm going to tell you a story, a real story, although I'm going to change the names in the story. A story that illustrates how these things are playing out today in the real world with real people, and not just the abstract concepts that we've been discussing as law professors. So the story's about a guy, I'll call him Juan Gomez. That's not his real name. But he was born in Mexico. He's a real person. And when I was practicing law, he came to see me one day after telling me that he had seen 4 or 5 immigration lawyers over the course of his 22 years in the United States. And, quote, none of them have ever been able to help me. He told me that his goal was to, quote, get legal, end quote, in the United States of America. And he'd been living here for more than 2 decades with a fake name and a fake Social Security number. He'd also fathered children who were born in the United States. Now, those of you who follow the popular press on the birthright citizenship will know that the pejorative term for these folks is anchor baby. The theory being that if you're born in the United States under the 14th Amendment Clause and your parents are not legally here, you can anchor your parents. You can give your parents status somehow. This is thought to be a bad thing, so there's a pejorative term attached to it. Unfortunately, most of the people who practice in this area know that you can't actually anchor your children. First, you can't even, or your parents, you can't apply for them till you're 21, and even then you can't normally get them status. So my friend Juan Gomez, who came to see me, was not able to get himself legal status through his children, despite having had them here. And the tough 1996 changes to the immigration laws had made him inadmissible to the United States. So basically, he was stuck between a rock and a hard place. He was living in America with this false identity and had children here and couldn't get legal. So he was sitting there expectantly hoping that I had the grand solution to his problems. And I looked through his papers, and it took me about 45 minutes to an hour. And I said at the end of the 45 minutes to an hour, well, the bad news is that there's no amnesty going on, and I can't get you a green card through amnesty. But the good news is you're an American citizen, and you've been an American citizen since the day you were born. And I'm really sorry that these lawyers you went to see didn't know this, but if you take these papers and you fill out a passport application and go down to the post office, I'm 100% certain that a passport is going to arrive in the mail in about 6 weeks, and you will then have proof that you're an American citizen, and you can go straighten out these other legal problems you've created by running around with fake names and such. And so he was very happy that he had seen me that day, and he ran out and applied for his passport, and sure enough, it came in the mail 6 weeks later. Now, some of you are laughing at this, and some of you are probably puzzled and saying, how can this be? Well, this can be because the 14th Amendment isn't the only way that you get citizenship in America. In fact, we have another strand of longstanding jurisprudence with Latin terms attached to it, jus sanguinis, citizenship by blood, where you derive citizenship through your parents. And this is the John McCain story, partial John McCain story, but you can derive citizenship through your parents. And one of the fundamental truths about the way Congress has handled citizenship through your parents over the centuries is that they have made a complex mess of it, such that it's very, very difficult to tell if somebody is a United States citizen who has derived it through his or her parents. In fact, it's so difficult to tell that there's a gentleman you may have heard about named Winston Churchill who thought when he was born that he was not an American citizen. He thought he was purely a subject of the British Empire. And in fact, Congress didn't know he was an American citizen at birth, and so they made him an honorary one later on. But it turned out later that, in fact, he was a U.S. citizen at birth because of the 14th Amendment, and that he had derived U.S. citizenship through his mother, who was an American citizen. None of this, of course, was known to him, even though he was an elite, educated person. And it only became obvious later on, years later, that in fact he was a citizen at birth. Now, where does this play into our interpretations of the 14th Amendment? Well, currently, as I said, there's kind of an uprising going on in the constitutional culture, and it's reflected in debates over birthright citizenship. But one of the truths of this debate is that today it's actually commonplace for people to believe that they're American citizens but be unable to prove it. And in fact, the Brennan Center did a study recently where they estimated that there's about 13 million American adults living in the United States who have no proof that they're American citizens, no documentary proof. And they have recently run into problems because in our attempts post 9/11 to enforce security measures in the United States, it's increasingly the case that people who thought they were American citizens at birth are now required to prove this fact to the Department of Motor Vehicles, to health officials who seek proof that they're American citizens before providing them with medical benefits. The rules for birthright citizenship are pretty simple. You produce a valid American birth certificate showing that you were born somewhere in the United States that Congress says is part of the United States, and you're a citizen at birth. But if you're a derivative citizen, you're in this morass of complicated technical rules. Mr. Gomez just being an example of one person who was falling within that category. And if we get rid of the birthright citizenship presumption, we will place everybody in America, not just people that we intend to target apparently with the change in the policy, the children of illegal immigrants. We'll place everybody in America within the category of Mr. Gomez. Everybody will now be required to prove citizenship somehow through derivation through their parents. So what would a regime look like if we do that, if we give it up? Well, today, most Americans have a pretty easy way of proving their citizenship. They show up with their birth certificate. If they weren't so presumed, if we changed the meaning or revised the meaning, we'd end up with a situation that hundreds of Americans are in today, the ones that I deal with, people born overseas to the family members, people born overseas to American service members, for example, or missionaries or oil company employees, or the children of Brad Pitt. The State Department and the Department of Homeland Security have to make a determination whether you're a citizen or not, if you're one of the Americans in those circumstances. And they charge a lot of money to do that. And there's a lot of paperwork. And it can take weeks or months or years for you to prove whether you're a citizen. And the government makes a lot of mistakes when they do these determinations. If I have any judges in the audience who are federal judges, they may be aware that the government often arrests and attempts to deport American citizens. This is a common phenomenon today because the government doesn't know that these people are citizens. And there are lots of lawsuits about their right to be in the United States. So what does it mean as a practical matter if we reinterpret or revise in an attempt to solve a pressing problem of illegal migration or undocumented immigration? Well, if we try to do it through the elimination of what has been a long-standing and simple legal rule that everybody can understand, we are going to place ourselves likely in the morass that I described earlier with my little story. Now, being an immigration lawyer, I'm all in favor of full employment for immigration lawyers. If every hospital in America has to hire an immigration lawyer on their staff to determine the citizenship at birth of every child born in the hospital, I'm sure there are going to be a lot of jobs for lawyers. But it's not a problem today to find employment for immigration lawyers. Just not a problem. In fact, there's a deep and dire shortage of them today. So what would be the net result? Well, getting back to practical details, at some point we'd have to create a national registry of who's an American citizen. We don't have such a thing today. Few members of this audience, which I take to be mostly members of the elites in America, are likely to be affected by this. Most of you probably have the type of resources that Senator McCain and Senator Obama had to fight back attacks on their citizenship. You could hire a lawyer. You could file the paperwork. You could prove that you derive citizenship at birth. So the burden of proving citizenship is likely to fall mostly on the less favored elements in society. And as Professor Rodriguez has described earlier, the egalitarian rules do have the function of creating a system where everybody sort of ends up in the same, starting at least on the same level in some sense. Most of the U.S. citizens today, for example, who get deported are the less educated, minorities, people whose documents are doubted. And this trend will definitely accelerate if we eliminate birthright citizenship. So in kind of wrapping up here, what would be the result if we decided to revise what's been the understanding of the Constitution for over 100 years, the fact that you're born in America within the territory that Congress has elected to be the geographic boundaries that make you a birthright citizen? First, we'd have lots of children born every year in America who wouldn't be American citizens. Many would be stateless. Some of the legislation that Roger Smith was talking about earlier would render thousands and thousands of people born in America every year citizens of no country at all. The children of asylees, the children of refugees wouldn't have citizenship at all under this legislation. Now, we've seen what happens in other countries where this situation occurs. There have been some European countries that have not had the jus soli rule that we've had. And what you end up with is a class of exploitable denizens, people that are a lower caste in society that don't have the rights, the advantages of other folks. You don't necessarily get rid of unauthorized immigration either. Although proponents of changing the rules seem to think that this is going to be an obvious deterrent to people, that they won't come to America if their children born here will not be American citizens, the experience of other countries has been the opposite. People still come, they just can't get legal. And you end up with a larger and larger class of people who are unauthorized. Next point, the benefit doesn't seem to outweigh the cost. If we change this rule, we're going to cost every American a tremendous amount of money. It might make more sense to simply take the money that we might spend on eliminating birthright citizenship and spend it on perhaps making our immigration laws a little more rational and then perhaps enforcing them. But finally, birthright citizenship has been part of our legal culture for more than 100 years, and it has been the rule since the dawn of the Republic. I think it's very clear from legal history that common law rule that we adopted from the British was that if you were born on British soil, you were an American citizen. This was rejected in Dred Scott. The 14th Amendment was an attempt to overturn Dred Scott on this issue specifically. So it's now been a rule that's enshrined in our legal culture since the dawn of the Republic. And we ought to have a better reason for changing it than just being frustrated with the federal government's inability to enforce our immigration laws. So in short, the policy arguments for retaining our current rule, in addition to the history of the 14th Amendment, are very, very strong. And the arguments against this rule on a policy basis are fairly weak. Even if you buy the argument that the uprising in the constitutional culture should cause a change in our interpretation so that we interpret things differently than we've been doing for over 100 years, I'm not sure why we would want to do that. And I think this is best illustrated by the old Texas saying, "Don't squat with your spurs on," which is my final suggestion for how we should be considering the meaning of the 14th Amendment Citizenship Clause. Thank you.
I'm going to be very careful not to do that. Thank you very much. It's a pleasure to be here. I'm a little daunted by this because I am definitely not a scholar of the 14th Amendment or the Reconstruction era. So I'm just going to offer a few observations on some of the comments, on some of the papers of the other folks. And first, with regard to the very provocative theory that Rogers and Peter Schuck put out in their book in 1985, I think it's just worth emphasizing that there has been a very substantial critique, as Rogers noted, of their consent theory of citizenship, especially by Jerry Newman, on both the historical and the legal analytical grounds. So I don't think we want to repeat those. We don't want to engage in that debate. But I do think it's important to note that there have been very substantial analysis refuting the approach of reading of the 14th Amendment that's proposed there. I guess I would only note that it seems, Rogers, that now this is a slightly different version of consent theory, not as to what the 14th Amendment intended originally, but rather what the polity now apparently has consented to, namely birthright citizenship, which I find some solace in that you're recognizing that, but it's troubling, it would seem, to try to rely on the failure of Congress to act based on what in the end are relatively few proposals along this lines, few in terms of what gets introduced and rejected or it gets failed to, is not enacted. So I would prefer to rest the right to birthright citizenship in the 14th Amendment on the much stronger grounds that Jerry Newman and many others have noted, rather than on what's happened in the 20 years since the novel doctrine was first proposed. Christina's approach, which I find very compelling in terms of reading the broader purpose of the 14th Amendment, I think is very important, and to me it drives home that the nexus that the Supreme Court has consistently found between immigration and race and racism is very significant in that respect. I mean, that the court, especially in cases where the court has been protective of immigrants' rights, has often been rooted in its recognition that at the heart of whatever the discriminatory provision may be was hostility towards a particular race, be it Chinese or others. And in cases where the rights were protected, that was specifically noted. And as you said, that's very clear, obviously, in the Yik Wo case. It's very evident in the Wong Kim Ark case. The other case that I think is very significant in that evolution is the Takahashi versus California Fish and Game case from 1948, where the court struck down a California statute that denied rights to persons of Japanese origin to fish off the coast of California on kind of a mix of preemption, race discrimination grounds that were not entirely clear, but that case then became the direct precursor to Graham versus Richardson, where the court held directly that alienage was a suspect classification under the Equal Protection Clause, and that alienage classifications had to be subjected to strict scrutiny. So that the significance and the nexus between race and immigration, I think, is critical. The second point I guess I would make is just to add to what Margaret outlined so well in terms of the very practical consequences of adopting a rule that would turn on the status of the parent rather than the location of the birth. There are incredible complexities in the immigration laws, naturalization laws already. There's a whole, but we would have to establish, it seems to me, a whole additional set of standards and procedures for deciding who is a citizen and who isn't. And trying to think about how that would actually work raises a lot of additional questions, it seems to me, because we would have to have this system of parent status determinations at the time of birth. And then among the questions it seems to me that would arise is, which parent are we talking about? Is it enough if one parent is a United States citizen? Do both, if one parent is a citizen and one isn't, if one parent is undocumented and the other isn't? Does that divest the child of their citizenship rights? And if it is one parent, which one? The focus often, typically, especially with the term anchor baby, is all about the mother. What's the status of the mother? Well, what about the status? Who is the father of that child? And how do we determine that? What system of proof and verification do we establish? And it is kind of striking, I guess, to me, that just as we're celebrating the openness and the regenerative power of American democracy with the election of Barack Obama, are we talking about a system that would conceivably cause us to ask, what was the status of Barack's father when he was born? He was here on a student visa? Was it still valid? Had he taken too few units? Had he worked without authorization? Had he overstayed that student visa? And would that somehow question the citizenship status of our president-elect? So we would have a whole series of questions about which parent, how, and then the question would arise, who decides that issue of the parent's status? Is it the federal government? Is it the state government? Is it the county that issues the birth certificate? Which that has some echoes, for me, of the current debate over the role of states and localities in enacting immigration legislation, because the narrow question in a lot of those cases is, are the particular schemes that states and localities have enacted preempted by federal law? But the broader question in those cases is, do the localities, or is there an easy and appropriate way for non-federal governmental entities to definitively determine the immigration or citizenship status of people residing within their particular area? Because those determinations, for the reasons that Margaret said and others, are incredibly complicated, and the varieties of immigration status are incredibly broad. So lastly, let me just say that again, the third area that just I think is significant to me is if you read the language subject to the jurisdiction in the Citizenship Clause of the 14th Amendment as a qualifier of rights under the 14th Amendment, then does that have implications for other clauses in the amendment or for other rights in the Constitution? Because each of the four clauses in the 14th Amendment actually uses a different formulation. The all persons subject to the jurisdiction of the United States is in the Citizenship Clause. Citizens, of course, is in the Privileges or Immunities Clause. Persons is used in the Due Process Clause, and persons within the jurisdiction of the states is used in the Equal Protection Clause. Every one is different. And then there are other provisions of the Constitution that refer to the people of the United States. And in particular, under the Fourth Amendment, it's the people who are entitled to be secure from unreasonable searches and seizures. And that, in turn, has given rise to some arguing that people are not the same as persons within the Constitution, and therefore undocumented aliens inside the United States should not be protected by the Fourth Amendment to the same extent as others. So all of that, raises a whole host of questions, it seems to me, when we start focusing or parsing these particular words. And the work, obviously, of many advocates and scholars has been to bring immigrants into the mainstream of constitutional protections, to end the reliance on the pre-individual rights era that gave rise to the Chinese exclusion cases. In the words of Lou Henkin, to end being mired in the pre-Brown versus Board of Education era, being mired in the Dred Scott era. So I fear that parsing this language of the 14th Amendment would do precisely the opposite and drag that effort back to the Dred Scott era rather than to allow us to develop fuller and more complete constitutional protections for non-citizens inside the United States.
Okay, great. So thank you to all of our panelists. We have just under 20 minutes for questions and discussion. Do any of the panelists quickly want to respond to each other? No? We'll just go to questions.
I would, if I can ask
Yeah.
Lucas, if unauthorized immigrants are not subject to the jurisdiction of the United States, can they be deported under U.S. law or charged with crimes? Since
I think that was part of what, and Christina can speak to this better, I mean, part of the discussion in Wong Kim Ark is all about everybody being subject to the jurisdiction of the United States for purposes of enforcing the law rather than providing protection, I think. And so I think the answer presumably, you know, could conceivably be endowed, but presumably we would not have a regime where they could not be subject to the...
I only ask that because invading armies wouldn't be subject to our criminal laws. You know, they're invading. And children of diplomats would have diplomatic immunity, and the sovereign Indian tribes presumably wouldn't be prosecuted under. So I'm just curious whether you think that would be plausible.
Well, there's a passage in Wong Kim Ark that talks about how people, even temporary sojourners, have to be understood as subject to the jurisdiction thereof. Otherwise, it would defeat the sovereignty of the United States. And the noted exceptions were, of course, the common law exceptions of the invading armies and ambassadors. The difficulty is the Native American tribes and what it actually means to be subject to the jurisdiction thereof. In Wong Kim Ark, the court talks about I don't know if they use the language dependent nations, but that eventually comes out as the language for describing them. So it's an ambiguous status where they might not be subject under certain circumstances to criminal prosecution, but ultimately Congress has control over their status. And so and it was also clear that the framers of the 14th Amendment intended to exclude them and struggled over what language to use, which is why they use subject to the jurisdiction thereof instead of within the jurisdiction as they use an Equal Protection Clause. But it raises the problem that Rogers and Peter begin their analysis with.
Okay, so start with Judge McConnell and then...
beyond what you've been talking about, but I'm just curious if Michael Kent Curtis and Richard Ains and Akhil Amar and others are correct that the incorporation of the Bill of Rights took place through the Privileges and Immunities Clause of the 14th Amendment. What implication does that have for aliens? Do aliens not have Bill of Rights rights?
He wants to answer.
Yes, if you look at the debates, it's quite clear that Bingham and others believed that aliens had all the due process rights, which would include all the process rights in the criminal procedure processes in the Bill of Rights, for instance. But would aliens have the right to bear arms? I guess not. Would they have the right to free speech? Well, if you have the Supreme Court's approach to corporations, which is they have a right to free speech because we have got a right to hear what they have to say, then the answer would be yes.
What?
Can't hear.
What, Jack, what are you saying?
Yeah, well, and that was an argument. There was an argument that was made in, I forget the case, but it was the anarchist case. And it was made by John Randolph Tucker, and he said that I admit some of these people are aliens, but because of equal protection, they get all these rights that... yeah, but they would get all the Bill of Rights rights, he argued.
I think the other related point that I would make is not directly responsive to your question, but the I guess, argument against what I've laid out as the egalitarian understanding of the Citizenship Clause is that it's obvious that citizenship status comes attached in the original 14th Amendment with certain sets of rights that belong only to citizens. And then the Equal Protection Clause protects all persons, and the court later interprets in Yikwo that to apply even to the disfavored Chinese. And so that you could still read the Citizenship Clause itself as being exclusive in a way that wouldn't necessarily have the caste implications that we're talking about because of the protection against arbitrary state power that the Equal Protection Clause and the Due Process Clause provide. And so that's another way of saying that I think there is conceptually possible within the realm of the 14th Amendment different tiered understandings of membership. And so that you could, I think, consistent with our understanding of it, have a 14th Amendment that doesn't necessarily extend some of the Bill of Rights to aliens.
Yeah.
Short question for Rogers, short question for Christina. The question for Rogers, are you suggesting, as a principle of constitutional interpretation, that the repeated failure of Congress to enact a proposition demonstrates the unconstitutionality of the proposition or the constitutionality of the contrary proposition? Because I can think of both good process reasons why that shouldn't be a rule, and I hesitate to think that you would want to actually apply that rule broadly across all fitting fact patterns. The short question for Christina, you've given an account of the meaning of the Citizenship Clause, but I'm not sure what original adds to meaning. That is to say, you've read the text, and the text says all persons born, right? I can produce a very nice reset button egalitarian reading from that alone. You've told us about some cases that were decided long after Reconstruction. So does it matter whether this is an original meaning? Are you saying that your reading is an original meaning, or are you just giving us a meaning and you add the word original to be polite because of something about the bent of this conference?
Well, I'd say two things. First, if you take the view that Peter Schuck and I did, that Congress has the authority to decide on these birthright citizenship rules, then for children of unauthorized aliens, then the fact that people have proposed in Congress to exclude them and Congress has chosen not to do so satisfies the Constitution the way we interpret it. Congress has approved them, and I don't think that's very different from looking at legislative history as we do in judicial decisions often, and seeing that certain proposals were rejected and other policies prevailed, and so we assume that Congress does not intend the rejected proposals. Congress intends the policies that prevailed. But that doesn't go as to how to interpret the Constitution. The pertinent point there is that constitutional amendments have been proposed that would have, in the eyes of constitutional amendments that would have denied birthright citizenship to these children, and those constitutional amendments have failed. And yes, I think that if there are repeated efforts to alter a dominant constitutional understanding and those repeated efforts fail, then it is plausible to interpret the Constitution in light of the understandings that have prevailed. This moves away from strict originalism, but I have no problem with that.
So that if, for example, the Equal Rights Amendment had garnered 2/3 of the Congress vote, one state shy of 3/4 on 4 separate occasions rather than once, that would establish a constitutional proposition that equal protection doesn't care about sex.
Equal protection doesn't care about sex is, I think, pretty clearly not the logical implication of the rejection of the ERA. It is perfectly consistent to say what, in fact, is the case, that the ERA, which proponents like Ruth Bader Ginsburg have insisted would require strict scrutiny, that has been rejected, but that doesn't mean the Equal Protection Clause is unconcerned with sex. There is the position that the court has arrived at that some kind of heightened scrutiny, falling short of strict scrutiny, is appropriate, and rejection of the ERA does not prevent you from taking that position.
So in response to your question, Richard, I definitely thought it would be appropriate to talk some about the understanding that the framers of the 14th Amendment had of what the Citizenship Clause did. But I have two answers to your question that I think rescue some of the originalist idea that's animating the argument that I ultimately make. One is that we know, again, that they intended to repudiate Dred Scott. What exactly does that mean? did they just mean to establish that blacks could be citizens, or were they rejecting the reasoning in Dred Scott that there was the possibility of defeating someone's capacity to be citizenship because of their perceived inferiority, or based on some kind of consensual idea of the majority being able to endow people with citizenship status or deny that they ever had it in the first place. So in that sense, I think you can say the notion that there is at least an anti-inheritance-based idea on the grounds of race is present in the original understanding of the Constitution, because we know it was intended to repudiate Dred Scott. And I'm sure there's lots of room for debate about what exactly that means, but that's the starting point. And then the second thing I think I would say, and this relates, I hope, to the theory of originalism that Jack has been suggesting, and that's that, or that more generally we can talk about when framers choose, when they're addressing specific problems, to use general language. They use general language, and so the question is, what did they mean in the use of this general language? There's a specific intent to take out language that specifically noted that race was the basis on which citizenship could not be denied, and they used the general use solely rule to make clear that the common law rule applied to everyone born inside the United States. And I think from there, given that they use this general language, the question becomes, well, how do we understand what they meant that general language to do? And that's why I think one way of thinking about that is what the 14th Amendment was intended to do. And I think that I wouldn't one way or the other say that the early interpretations in cases like Yekwo or Strouder or those other cases where there's clearly an anti-caste, anti-subordination idea being formulated are authoritative, but that's just the next step to which I think you need to go to begin to understand what the meaning of those clauses are. And I wouldn't suggest that we should be limited in our understanding of what an egalitarian understanding of the Citizenship Clause should be by what was said there, because I think that there are subsequent developments that have shed more light on that. But I think you can ground that basic idea, either call it anti-inheritance or anti-caste, in the original understanding of what the 14th Amendment was intended to accomplish.
Well, I was going to speak to this very issue. In the debates over the Citizenship Clause of the 1866 Civil Rights Act, so some of the opponents said, like we were mentioning, oh, it's going to, you should vote against this, basically, because it's going to make Chinese citizens, it's going to make Gypsy citizens. And Lyman Trumbull, who is the sponsor of the act and a very well-respected lawyer, oh, there we go, his response was, yeah, you're right, it would. And if it wouldn't, there's some Germans in Pennsylvania that would be pretty disappointed. So I think that's some pretty strong evidence there that they intended this to apply, to certainly to the children of Chinese immigrants, which is as close as we got to undocumented. I mean, it was pretty clear that nobody wanted them, the people didn't want them to come and stay.
Yeah, but they were permanent resident aliens legally admitted by the U.S. government. That's the difference.
Okay, but maybe not to that specific point, but to the broader point that Christina is making, the anti-caste point. I think it's pretty strong evidence from the original.
But Lyman Trumbull also championed the exclusion of members of the tribes. So there is a real problem making sense of this amendment, and we don't like that exclusionary element. But really, the reputations of the book that Peter Schuck and I wrote really all take the form of the same move that Christina makes, and I sympathize politically with the move, but it's to say we're going to read subject to the jurisdiction as narrowly as we possibly can because we don't like the results, and so we'll say it excludes children of invading armies, diplomats, and members of the tribes. But if you ask for a coherent account of why they should be excluded and spin that out, it's very difficult to give a coherent, more general theory based on that exclusion that allows you to include everyone else that you want. I regret this, but I think it's true, and with all due respect to Jerry Newman, I don't think he adds anything beyond the points just made. Let's read it as narrowly as possible.
I'm sorry, go ahead.
I just wanted to say that, I'm not talking about Native Americans, I'm talking about immigrants.
Right.
And as you know, of course, you've written about, there was a wave of anti-immigrant sentiment in the country, only 10 years before, the know-nothings and all that. And I think these folks, the proponents of the Reconstruction amendments rejected that and made it pretty clear that they rejected that. And not everyone in Congress, but the proponents of it.
I'd also just like to make the argument, I think it's possible to say that undocumented immigrants today are functionally equivalent to the Chinese at the time. The fact that they were admitted for permanent residence is not the crucial issue. The crucial issue, I think, is the fact that they weren't thought to be permitted to be members of the polity. They were here, sure, as a legal matter, but the notion that there was a real distinction between legal and illegal immigration didn't exist at the time. And to me, if we're trying to figure out what was consented to, I think that the fact that Chinese were not thought to be capable of becoming part of the polity suggests that that their children weren't as well, but there was clearly a rupture in the way that was understood by the framers of the 14th Amendment between parents and children that I think applies also to unauthorized immigrants. And so it doesn't depend on the parent's status whether someone can be part of the polity. What matters after the 14th Amendment is the location of birth.
Still doesn't allow you to distinguish the tribal members whose children could become citizens in exactly the way the Chinese could.
Okay, I think we have time for one more question.
I want to ask a different question, probably Professor Rodriguez's, but it comes to you. But the amendment itself, when it's reported out of the Joint Committee, does not have a citizenship clause. When it's passed by the House, it doesn't have a citizenship clause. It goes to the Senate. They go to a 3-day private caucus. When they come back, Senator Wade, who's the chairman of that caucus, says, "We're not making any new law here. All we're doing is enacting something declaratory from keeping mischievous things like Dred Scott from causing us problems." And then I forget which senator made the motion, but he too says this is just declaratory of what the law is now. And I guess I'm just wondering, does that have any significance to your argument? I mean, is it different than if they would have said, we intend to overrule Dred Scott, like Miller says in Slaughterhouse, or not?
Well, I think that the Civil Rights Act of 1866 established the rule that was intended to overrule Dred Scott. And so the 14th Amendment Citizenship Clause, whether it was just to prevent mischief, was I think precisely intended to constitutionalize that rule. And for the same reasons, there was a 14th Amendment after this 1866 Civil Rights Act. There was a Citizenship Clause after that act. And so in some ways, this question, and this is the way the debate plays out in all other societies, is not necessarily a constitutional question. And so, but the fact that it has been put in the Constitution now means that legislative majorities can't revisit the idea of what they can't overrule the 1866 Civil Rights Act. And whether that was intended to have that, I think it was intended to have that purpose in order to give that a safer foundation. And so I think that that's not inconsistent with what I'm saying. Roger, if you know more about those particular debates.
No, I agree with you completely.
Time for one more question.
Neil Siegel from Duke. So I have the same question at the end of the second session that I had at the end of the, and that is the question of what we started with. What is new here, right? I think Judge McConnell is excited that something new is going on. I think I'm concerned that something new is going on. And I think a good way of putting the question is, what does original add, right? What does original add? Why, at the dawn of the Obama administration, are progressive constitutional thinkers thinking so seriously about originalism, about original meaning, about new original meaning, right? What is it about originalism that, that folks find so attractive? Is it that, as a matter of political practice, we think that it'll work for us the way it worked for conservatives? If so, why? Why has it worked for conservatives, and do you really think it works for folks who believe in an aspirational constitution? Is it that we think as a matter of interpretation, right, as a matter of getting the law right, it's persuasive, it's compelling? Well, you folks have just spoken about settled understandings, practical consequences, draconian impacts on the values we care about as a matter of constitutional law. Is all of that out? Or if it's not out because where construction doesn't just end at the original founding moment, we continue to construct, in what sense is that originalist? I think that's the bottom line question about what are we doing at this conference and why do we keep gesturing towards originalism? And what are we prepared to give up? What are we prepared to give up in the name of fidelity to original meaning? Because I think Judge McConnell is quite right, that if we're going to be intellectually honest about this, in ways, frankly, I don't think conservatives have been, right, then we have to be prepared to give certain things up. And if we're not, again, what are we doing calling ourselves originalists or new originalists? Particularly when conservative nominees of a conservative president before conservative Congress who are voting on their confirmations say we're not originalists. And they swear allegiance to Griswold. And they wouldn't dare criticize Brown or the court's sex equality jurisprudence. It's not exactly as if you need to be an originalist in order to succeed in translating politics into constitutional law, right? So I think it's a matter of politics it's misguided. It's a matter of honesty about how constitutional change comes about. It's wrong. And I think most importantly, I think it disables people's democratic constitutional authority.
Okay, so let's give
the thought
Doug
that they can
Kendall
actually change the meaning of the
opportunity
Constitution.
to respond.
You know, I think what I get out of this panel is how successful conservative organizations, anti-immigration organizations, have been in taking what I think is a garbage argument about text and history and making it the centerpiece of a debate that we're having here, and how in a whole host of areas, conservatives have taken the agenda, the legal agenda of the courts, using arguments that don't fly about the Takings Clause, about the Second Amendment originally, although I agree with Judge McConnell's view of the Reconstruction view of the Second Amendment, about immigration rights and about birthright citizenship. The things we're talking about constitutional law, are the areas where they're taking arguments, they're rooting themselves in the text, making claims based on the text, and controlling the dialogue because of that. That requires us, as progressives, to do two things in response. One, take on those arguments, look at the text, look at the history, see whether it supports the conservative outcomes at all. And two, look for similar arguments where the text supports outcomes that we like, and make those same arguments and say, yes, the Constitution matters, yes, the text matters, and it leads us to these outcomes. Those are the outcomes that the current Supreme Court, a majority of it, on both sides of the spectrum, listens to. That's where the law is moving. If you look at the debates in some of these cases, people take these seriously, whether you or whether anyone else in the room wants them to be taken seriously. And so those are the arguments that I think we should be looking at, thinking about, and not ignoring and not saying, oh, they don't matter. They're not, we shouldn't be talking about this. This is not where we want the law to go, because that's where the law is.
There is one recent Supreme Court case where this issue did come up, and that was the Hamdi case. Some of you may remember that Yasser Hamdi was an individual found at Guantanamo Bay, Cuba, who was born in Louisiana. In fact, the facts of his birth are very similar to the facts of Bobby Jindal's birth. Bobby Jindal being the current governor, Republican governor of Louisiana. They had very similar facts of their birth. Both of them birthright citizens under the 14th Amendment. Children born in the United States to parents who were temporarily here. And one argument made by some of the folks in the Yasser Hamdi case was that somehow he wasn't really a citizen of the United States because he had left the United States at a young age and never come back and then taken up arms against the U.S. And the court did reject that argument. So
I know
I'll just mention that.
We have to go. I just want to say one quick thing, that I think that there's this assumption of a continuous constitutional history. And to borrow Barry's word of rupture, there are many ruptures in that history, and this is one of them. And I think understanding what happened and what was understood at the time to be the meaning of the things that were added to the Constitution is sort of a crucial, it's not a recovery project, because obviously people have been doing this for a long time, but putting it all together in the form of a discussion, I think, is a way of highlighting the idea of constitutional development and the significance of this particular moment in that development.
Okay, we'll have to let that...
Can I just simply say that even though Neil and I are not related, we have the same last name, and I really want to encourage the subsequent panels to address the question that he put on the table, which, precisely because it is a provocative thing that you've done here, and the question is, what are the stakes? And it would be, I don't know of anyone who rejects the relevance, in some sense, of text and history and structure. So it needs to be sharpened a bit about how exclusive the authority is. If it turns out, I know that you want to end the session, but the distinction between interpretation and construction that's been thrown out, that makes enormous space for a living constitution? Is that what we're talking about as originalism, my colleague? Or something else? But it just would be very helpful if we could join that conversation. So in the interest of time, I'll stop here and just say, please, people up next, do so.
Okay, so if you all could join me in thanking our remaining panelists.